Consolidated Restaurant Operations v. Westport Insurance Corporation Council, and we want to welcome, of course, our colleague, Judge Connolly. Thank you so much for joining us today. And Judge Halligan, as you see, is on the screen. We will try to be cautious to be able to hear when she has questions and give her an opportunity to ask whatever she needs to ask. Go ahead, counsel.
Thank you, Your Honor. Good afternoon, Robin Cohen on behalf of Consolidated Restaurants Operations, Inc., better known as CRO. We would like 3 minutes for rebuttal.
You have it.
Okay. This appeal poses 2 issues. One is, did the First Department err when it rewrote the policy, finding that the words direct physical loss or damage can only mean tangible, demonstrable damage to its property? Second, even if that were the appropriate standard, did the First Department err when it violated New York's liberal pleading standards by rejecting CRO's allegations that COVID-19 physically and tangibly altered its property without any evidentiary record?
Counsel, can I ask, are you, over here, thank you.
Sure.
Are you arguing that loss of use from some completely exogenous external event constitutes direct physical loss? Or is your position that as long as there's some physical substance on the property that renders it uninhabitable, that's what constitutes direct physical loss or damage?
We are arguing both, Your Honor. We are arguing that if you have a physical substance like COVID and it goes onto your property and it physically causes your property to be unsafe so that you physically cannot use that property in whole or part.
But counsel, how does that constitute physical damage or physical loss?
So physical loss is different than physical damage. Physical damage is physical harm. What we say physical loss is deprivation of property as a result of a physical event.
And
So
how
is this
does the government?
loss or damage? What are we talking about here?
Well, that is physical loss, Your Honor. So if you have deprivation of your property in part or in full as a result of a physical...
What about the government's orders with respect to the property? How does that impact your definition?
If we only had government orders, that would be a pure loss case, and we would not be able to get
Well,
covered.
it might be loss of profits. How is it physical loss?
So loss, without the physical to modify it, would be economic loss or reputational loss. So for example, if the restaurant got a bad review and we suffered economic loss because of that, that's not covered. If a competitor comes into the neighborhood and we, CRO, suffer loss, economic loss, because of that competitor, that is not recoverable. However...
But that's roundabout, isn't it? I mean, that's a completely external event. So I thought I heard you say that you were taking the position that a completely external event was also covered.
Your Honor, roundabout dealt with a pure loss of use case. It did
Well,
not...
due to some external event that caused that loss of use, right?
It doesn't matter if the physical event is outside the property or on the property. But once you have a physical substance that causes some physical event on the property, that constitutes physical loss. So it has
Okay, so you agree then, I just want to make sure I'm clear, that something has to basically break the plane. In other words, it has to come onto your property in order to constitute physical loss, and something that is, so for example, if you had not alleged that there was COVID-19 present on your property, that would not be an allegation sufficient to be physical loss. Is that right?
That is exactly right. And
Okay,
that is
thank you.
why we are not roundabout. Because roundabout was a situation where there was an accident outside of the covered property, and the street closed, and as a result, the theaters closed. There was no physical event on the property. We
But
agree.
let's get back to this. It says physical loss.
Yes.
Explain that to me.
Sure.
You've already said what it's, or partially said what it's not. Let's get to what it is.
So it's not economic or reputational
Got it.
loss, but it is if there's a physical event
Yeah.
on your property
Yeah.
that causes the air or the surfaces to physically make it unsafe on your property, that means, and you lose money or you are dispossessed from your property, that constitutes physical loss.
And
So
how, excuse me for 1 second. And is there some temporal aspect to this?
Well,
Right,
for-
because, part of the argument is you clean off everything and you can use it again.
Right. So first you have to establish that you have physical loss or physical damage. Once you do that, then the question is, what's the measure of damages? Then you go to the temporal limitation. They want to put the period of liability into the insuring agreement and really use it as an exclusion or a limitation on physical loss or physical damage. That is not how the policies work. If you go to the first page of the policy, that's record site 84, it expressly says this is an all-risk policy, it's in bold letters, and it says it's triggered either by physical loss or physical
So
damage.
how does the period of liability then come into play here?
So let's assume for the sake of argument that we agree that there's physical loss or physical damage on our property. Then the question becomes, how much are you entitled to? And then the temporal limitation comes in. You're entitled to economic damages from the physical loss or physical damage up until the point, if you could, and the word could is in the policy language, you could repair or replace the property.
What specific factual allegations did you make concerning the virus on your property?
So paragraphs 12 through 22 in our original complaint expressly discuss in detail what the process was. At that point, we filed pretty early. We were focused on the surfaces of the restaurants. And what we said is there were fomites that would come as a result of the spread of the virus. Those fomites would change the physical integrity of the surfaces. As a result, they would change, and we were entitled to damages as a result of that.
And
Now,
did science contradict that at all?
in fact, Your Honor, just the reverse. We attached, we put footnotes of scientific studies that supported our view. And then we amended the complaint, because this is a science that's growing. We amended the complaint, and paragraphs 12 all the way to paragraphs 38 talk in excruciating detail what the physical process is, both the change in the air, how the air alters and causes physical loss or physical damage. We also talked more about how those fomites get absorbed into the surface where it's very difficult to clean.
So you're saying it's physical loss or damage to the air?
Well, there's a physical alteration to the air
Okay.
that causes CRO to be dispossessed from its property. So because the air, it makes the place unsafe, we had a business interruption claim because no one was coming to the
That again
restaurant.
sounds like economic loss. I can't run my business
It's
because of
not-
the air quality.
It's not just the air quality, Your Honor. It is that the air microscopically
Yes.
has changed to make the property from being safe to unsafe, and the surface is the same thing. The foamite process is being absorbed into the surfaces to make
So
those...
let me take this example. Let's forget COVID for one moment. whatever it was, a couple months ago when we had, or actually I guess during the summer, when we had all that smoke because the fires in Canada come in, couldn't even see the front of your hand. I assume there were businesses that had to close, people wouldn't go in, they were coughing, it was affecting their eyes, their lungs, and so forth. But once the smoke lifts, nothing inside is damaged. Every piece of furniture still is available. Is that physical loss or damage?
For 60 years,
Yeah,
the courts throughout the country have used that example
Yes.
specifically as causing physical loss or physical damage.
because of the environmental impact.
Yeah, because
Are there-
I'm sorry.
Judge Hallahan.
I should say, are there New York cases you can point us to that hold that?
So there's not a New York case on point, but what I can point you to is the PepsiCo case, because that case,
But there, the product itself was altered, right? The soda, I thought there became at least unmerchantable. It sounded like it was pretty bad, whatever happened to it.
Right.
And so I think that's the property, the physical property itself could not be used ever. That was a permanent, I thought, effective destruction.
you are absolutely right, Your Honor, but under the First Department's decision, that would not constitute physical damage. The
But
First
counsel, in
Depart-
that, I'm sorry, in that case, they had to actually destroy, they actually did destroy the Pepsi product.
Absolutely, but that did not come into play in analyzing the case, meaning the Second Department looked at the case and they said because the function and value of that product was severely impaired, not because it was
There was a
destroyed.
diminution in value, which is a loss. It was a diminution in the value of the product as a
Well-
result of this substance that was,
Well, the court specifically said that in order to prove property damage, you don't need, and I'm quoting, a distinct, demonstrable alteration of the physical structure. And the court went on to say in that decision that if there's a physical event and you lose the function and value of your product, that constitutes physical damage.
Why is that not a loss? That sounds to me like a loss. The chemistry, the recipe for the Pepsi, excuse me, got messed up and it rendered the product unusable or at least unsaleable.
Yep.
That to me reads total loss. So what am I misunderstanding due to my total lack of sophistication about the distinction between damage and loss in this type of situation?
Because what happened in that case, and I agree it's not completely on par with the smoke, and I want to get back to the smoke analogy. But in that case, you had a physical event, meaning that there was a physical event, it was invisible, that occurred to the product, and as a result, that product became unsellable. Now,
And
if
that was damage to the product?
Absolutely, it was invisible damage to the product. The product was altered in a way that the
But
product,
that's the problem here. Nothing physical on the premises of the restaurants is damaged as a result of COVID. You simply didn't make profit. You don't have customers. You had to close. Whatever was that part of the argument, sounds to me like your reading requires us to read loss of use into this phrase, and we cannot add terms.
you cannot add terms, but it says direct physical loss or physical damage. But I want to go back to Your Honor's point, because I want to push back a little bit on that. Just because damage is temporary doesn't mean there's no damage. So to get back to your example,
But again, it's not really damage. Damage suggests repair, and there's no damage to any of the property.
we would disagree with that.
Okay.
Because repair really deals with measure of damages. You're putting repair into the insuring agreement, and it's not. So you can have temporary damage. Good examples, the ammonia contamination in the District Court of New Jersey case. There was ammonia spill.
But didn't that require remediation? People could not go there unless the ammonia was remediated, removed.
They didn't have any more remediation than we've had here, meaning
But
they...
you didn't allege, I don't think, correct me if I'm wrong, complete unusability. Right? And I think actually the complaint indicates that there was some utility that remained at the property. So it seems to me we would have to accept your argument that partial loss of use or diminution in use is sufficient. Am I right in the way I read your complaint?
No, Your Honor, 2 points. First of all, paragraph 35 of the original complaint and paragraph 50 of the amended complaint allege that 30 of our 55 restaurants were completely closed. So we have complete disposition, if that is the standard. But that is directly contrary to the policy language here.
But that's not because of loss of the property. That's because you didn't have people returning to the restaurant. That, again, sounds to me like economic loss. But counsel, your red light is on. Give you an opportunity to address that when you come back.
Sure.
You have
So
your
could I, sorry, Judge,
Go
could I
ahead,
just
yes.
ask one very quick
Yes,
question?
yes, go ahead.
I think in paragraph 63 of your complaint, you also allege that the virus might not actually be present on the property. What should we make of that in assessing your allegations?
Sure. That was dealing with the communicable disease coverage, and that is inconsistent with paragraph 36 and 61, where we made crystal clear that the virus was present and caused physical loss or damage. And we corrected that, Your Honor, in the amended complaint to make it crystal clear that there are many causes to our loss, which is both physical loss and damage caused by the virus and the orders. It was a combination. And the question becomes, if this gets past a motion to dismiss, is what is the efficient proximate cause? Meaning, what was the predominant cause? And the New York courts have weighed in on this so far, and they say it's the virus. So if the virus, between the virus and the governmental orders, if the virus is the efficient proximate cause, then that is sufficient to get us past the motion to dismiss.
Okay, thank you. You
Okay.
have your rebuttal. Go ahead, sir.
Good afternoon, Your Honors. Excuse me. Sorry about that. Aidan McCormack, may it please the court, counsel for Westport Insurance Corporation. I think it's really fundamental that we need to look at the contract language and really look at that and look at the plain meaning of it. I think that's critical because there was a lot of use of the word physical event. And I've unfortunately read this policy too many times, more than I can imagine, and it does not appear, that phrase does not appear in this insurance contract.
Counsel, to the plain language, can I just ask you briefly, what meaning does the phrase physical loss have as applied to real property, which I don't think theft or displacement, misplacement readily applies to?
Right. So, Your Honor, there are many courts that have interpreted that particular phrase. It's not limited to physical loss or damage. It's direct physical loss or damage to insured property.
Right. But what meaning does the word loss distinctly have as applied to real property then?
Yes, in insurance parlance, and certainly the way these insurance contracts have been interpreted, a physical loss is a total loss. Your warehouse burns to the ground. A physical damage is, God forbid, your warehouse is partially damaged by fire. And so in insurance parlance, and certainly the way the plain meaning of this language is, those words do have different meanings, but they're both require and absolutely require physical damage to insured property. In the case of the former, it's a total loss.
So
In
the
case of
distinction is, if it's damaged, you can repair it. If it's lost, you have to replace it.
Exactly, Your Honor. It fits right in then with the period of liability clause, which we know from record on page 115, which uses those two same precise words. They match up and they mirror themselves. I'm sorry.
And what can you, no, I appreciate that. What can you point us to as support for that understanding of physical loss as distinct from physical damage?
So
You said that's common parlance in the insurance industry, but where can we look to see that?
well, there's many cases on this phrase, and we've cited them in our brief. But I would say to you, you need go no further than the over 120 New York cases that have decided the issue before you. Now, I know they're persuasive and not binding on this court, and you make your own decisions. But those cases repeatedly talk in terms of you have to have a physical loss to the insured property, meaning...
I understand that, but specifically to the extent you're arguing that physical loss means complete destruction as opposed to damage, which means partial or repairable, where do we see support for that reading of the word physical loss?
Well, I would suggest to you it's plainly in the words, Your Honor. The word damage, right, I think we can all accept means something is damaged, not totally lost. And the word loss completes the circle. When you have physical loss, you have a total loss of the property.
But
And when you
can loss also mean diminution in value?
Not with the word physical in front of it, Your Honor. And also, just to be very clear, the definition of insured property does not include air, okay? It only includes the real estate and the furniture and the chairs and the table. And you can study this complaint all day long, and including the amended complaint. And there is not a single factual allegation of a table or a chair or a knife or a fork or a refrigerator or an oven that was damaged and needed to be discarded, needed to be repaired or replaced.
So
Is there
if
any
all
coverage, I'm sorry, go ahead. No, no.
If you have an all-risk policy and they don't typically cover the release of noxious gases or something like that, that would require some special rider?
So it depends upon what the noxious gas is.
Because you said you can't, air is not property, and I just want to explore that.
Oh, okay, yes, okay, certainly. If the air is just in the air, right, you are correct.
The air is always in the air.
But if in the case of the Oregon wildfire case, right, where it permeates property such that the property, the insured property,
Yeah.
has to be discarded or repaired, cleaned, it's heavily built in, then you have an insured loss resulting from a gas.
But if you had a dangerous gas leak and you had to evacuate the premises and you couldn't reopen for 3 weeks, that's not going to cut it under this kind of policy?
That would not cut it under this policy. That's right, Your Honor. Now, let's look at Gregory Packing, right? They love to cite Gregory Packing, which is a New Jersey case, so it's not New York law. It's an unreported decision from a federal district court. That case involved ammonia entering the premises and permeating the premises. So much so, when one of the judges mentioned it, so much so they had to go in hazmat suits and remediate the whole property. And the court in that case said that is a physical loss or damage, and therefore it's covered. But what they don't want to mention to you, because they don't, is that since Gregory Packing, 10 New Jersey cases have ruled on COVID, and they've all affirmed dismissal of the complaint because they don't
So
allege
in the
direct
case that
physical
you
loss.
just described, do you agree that that was loss?
I will say this about Gregory Packing, there's not a lot in the decision, but I really don't have any quarrel with it, nor do I have any quarrel with PepsiCo. I mean, PepsiCo, the product was the soda, the product was infiltrated by another product, I think it was damaged sugar, it destroyed the product had to be thrown out, that's destroyed. That's repair or replace,
So
that's
does it
replaced.
focus
So why is-
more on some action that you then have to take?
That's right. And roundabout, we'd set out. Roundabout doesn't say, and just for the record, I want to be clear on this, the period of liability clause is in the insurance clause. If you look at record 113, the time element cover, where they're seeking coverage, section A, period of liability is built into the insurance clause. So these repeated references to it not being in the insurance clause are frankly inaccurate. But the way it's built out is you have that period of liability clause, which Roundabout looked to and said, when you look at that, that informs us, reading the contract as a whole, that in order to have physical loss or damage, something must need to be repaired or replaced. And we're all sitting in this courtroom today. Same furniture, same walls, same ceiling, nothing's happened. Was
Counsel,
certainly.
You say you have no problem with, no quarrel with Gregory Packing. So tell me, if you would, why is ammonia different from COVID? I take your point about the subsequent New Jersey cases, but why is COVID distinguishable from ammonia?
Yeah, I did caveat and say there's not a lot of facts in Gregory Packing in the decision.
I understand.
But what happened there is that the ammonia got into the building, hazmat suits were needed to go in, and environmental remediation needed to be performed. That, I don't know the details of what they did, But it sounds to me like they need to do some serious remediation of the premises, meaning the insured property. Obviously.
So is
that's
the
why we-
point that the physical property and not the air was affected, or that the air was affected in a really bad way? I'm trying to understand your distinction.
Yes, it's the former, Your Honor, that the ammonia damaged the property, and it had to be remediated. So it was the same colloquy we just had, which is, if something's bad in the air, is that direct physical loss to insured property? Answer, no. If
So with
that
the
air-
smoke,
if that-
sorry, go ahead.
If that air penetrates the surface, in the Schlam and Stone case, for example, the debris from 9/11, if it permeates the surface and requires repair or damage to the property, in that eventuality, absolutely covered.
Can you address
So with
the, I'm sorry, go ahead, go ahead.
No, I was just going to say, with Judge Rivera's smoke hypothetical, it sounds to me then, if the smoke permeates all of the furniture, the carpets, et cetera, and they have to be replaced, you would say that counts. But if it's just in the air and no one can come in for a week, that doesn't count, because why? That's just loss of use?
That's right, Your Honor. There's no direct physical loss or damage to insured property in that instance. And I also wanted to just remind, or just, if I may, mention to the court that remember that the loss, the financial loss, which Consolidated certainly incurred, as many businesses did during the pandemic, unless you were, allowed to stay open, unfortunately, like hospitals, it was a very bad time for businesses. I don't dispute that. But the financial loss that they incurred was not because the tables and chairs were destroyed or broken, right? It was because there was no foot traffic. And why was there no foot traffic? A, people were afraid, rightly, and B, the government said, you're not allowed to go in there. But you can, as paragraph 31 of the complaint alleges, they could have takeout, they could have, delivery services and things like that, which they did perform to.
But pre-mandate, didn't they voluntarily close some of their dining spaces, like, because of the risk inherent in using them?
That's right, Your Honor. My member of the yacht club, we closed our dining space long before the orders
That's
came.
got a sort of lost sound to it. They felt that the risk that was posed by the virus, both in the air and on the surfaces, because I was going to ask you that question as well, because it's, part of their argument is that the viruses are in the air, then they become fomites, and they fall to the surface, where they stay for some period of time. That sounds a lot like the ammonia that damaged the property in Gregory Packing. Be that as it may, they voluntarily, out of caution, closed their space to account for that hazard in their restaurants. How is that not a loss?
If you use the word loss alone, well, probably we would agree, but that's not what the policy requires. The policy requires that the financial loss you incurred is resulting from direct physical loss or damage. And there is no physical loss or damage that caused their financial losses.
That brings me to my counter question. Fomites on the counter, not direct physical damage or loss?
It's a fancy word for a surface that may transmit, sadly, a virus from one person to another. It does not harm the surface, Your Honor. And the plain meaning, and any ordinary person on the street would tell you, if you said, my chair, this chair right here was damaged by a virus, wouldn't believe it.
Is that because you can clean it?
You can clean it, that's right, Your Honor. And yes, you may need to clean it many times, but what's the difference? I mean, I know, I don't want to make light of the situation, because we all know it was very serious, we all lived through it. But they're cleaning with Lysol instead of Pine Sol every night. Okay, that's what we're talking about. And regular cleaning of a restaurant, we all hope, is occurring anyway. I'm not suggesting that they didn't have to do more, but it isn't physical loss or damage to insured property where you can wipe it down.
But counsel, aren't you asking us to evaluate? Over here.
I'm sorry.
Aren't you asking us to evaluate scientific allegations prematurely at the pleading stage?
Not at all, Your Honor. 3211 was given by the legislator to the court system for a reason. And there are jurisdictions, not this one, which say that that should be very, very rarely used. But in New York, it's a tool that eliminates cases early and for good reason. This is a contract dispute. This is perfectly suited for 3211 dismissal.
Well, even if perhaps I've misunderstood the science argument, you can, correct me on rebuttal, but again, this is my question about the temporalness of this. it's not like you can never use the chair if COVID got on it. You clean it.
You clean it, and you sit back down.
And that was known even then.
That's right. That's right, Your Honor. But so to your point, in the first department, if you read 2074 of the record, not only read the complaint, they went the extra step and read the proposed amended complaint. And my reading, their reading, same, said there's no there. It's just there is no direct physical loss or damage to insured property that caused their financial losses. It's not the warehouse was damaged or the warehouse was burned to the ground or something like that.
You're also making the argument that even if we didn't agree with you, there are these particular exclusions that would apply. Is there anything you want to add about what's already written in the brief?
That's correct, Your Honor. I would just say this, that the contamination exclusion that's in the contract can readily dispose of this case. I think there's quite a few Supreme Court justices who wouldn't want you to stop there, to be blunt, because there's a huge caseload below me. And so resolving the primary issue is for what it's your discretion, but I think it's important. But the contamination exclusion specifically says there's no coverage for virus. And unlike some of the arguments that have been made, it doesn't require physical loss or damage. When you look at it, it doesn't alter the meaning of the insuring clause. It's just an exclusion. It's red seriatim under the Latin, meaning on its own, can't create ambiguities, can't increase coverage. And so I would say that exclusion certainly bites and resolves the issue on its own, but I leave it to your discretion as to whether to think of other things. I think I would just close by saying that, obviously a very important issue, and thank you for taking it up. I think a lot of the lower courts are looking towards this decision. And, there was one argument made that a lot of the cases that are out there only dealt with the exclusionary issue, and I would respectfully say that's just not the case. There's 172 federal appellate court decisions on this issue, every single one of them unanimously dismissing these kinds of allegations. There are a handful that dealt with the exclusion, but by and large, they all said there's no direct physical loss or damage.
Because there may not be these kinds of exclusions, but the language is more commonplace in the policies.
This phrase, direct physical loss or damage, and the requirement that the losses result from that, I wouldn't say it's in every policy. Schlamm and Stone had slightly different wording, but it pretty much is standard. If there's no further questions. Thank you, Your Honor.
Thank you. Before you get to everything else you want to say, and I certainly appreciate counsel's comments about the necessary guidance, why isn't he right that the contaminants exclusion addresses this case, perhaps not others, but addresses this case?
Because belt painting, this court, in belt painting made it clear, if you have prefatory language that is in this exclusion, that is only applies to traditional environmental pollution. And so that's not what we have here. So for example, this policy is almost identical to the policy in belt painting. That's why it doesn't apply.
Ms. Cohen, did you find any SARS or COVID virus in any of your restaurants?
Yes, Your Honor, we did. We did. In fact, one of the facts that we have alleged in the amended complaint is we started closing many of the restaurants, not voluntarily, but it was voluntarily, but it was because the air and the surfaces were dangerous, and therefore we had to close down a lot of the restaurants.
Counsel, to go to these other cases, mentioned federal cases, and they're not binding, of course, on us, but to the extent we might find them persuasive, cases like Northwell, right, in the Southern District, Judge Rakoff, is there anything you would say to distinguish your case from those decisions, or would your argument be that they just were wrongly decided?
3 points, Your Honor. 99% of the COVID cases that are cited in the First Department decision are all loss of use cases, are all governmental order cases. And what I mean by that is they did not allege that there was any COVID on the property. In fact, the Michael Seta case which is one of the predominant cases, expressly distinguished its case, meaning its facts, from a case where you have a physical event, where you have intrusion of COVID on its property.
That doesn't seem to be the Northwell analysis,
True.
right?
That's my second point. On Northwell, the difference in the policy is this policy not only expressly says that it's an all-risk policy, but this policy expressly covers contamination from ammonia, radiation, mold, a lot of different invisible contamination, contaminants that can be temporary, that do not cause structural damage or structural repair. So if you're a reasonable policyholder and you see this policy that's an all-risk policy that expressly
But
covers...
is that kimchi?
Well, kimchi is actually helpful to us.
But kimchi says persistently, to the contrary, we agree with the district court that the virus's inability to physically alter or persistently contaminate property differentiates it from radiation, chemical dust, gas, asbestos, and other contaminants whose presence could trigger coverage.
So 2 points. Kimchi made it clear, if you have an invisible contaminant that causes physical loss, it doesn't have to be structural damage, but causes physical invisible damage, that's sufficient. Where kimchi went wrong is that kimchi said there is this spectrum, and dust is on one side, that's innocuous dust, and then you have these E. coli and ammonia on the other side. And then the question is, where does COVID fit? Now, Your Honor suggested COVID should fit more like innocuous dust because you can just clean it up. That is directly contrary not only to our allegations in the complaint, not only to the scientific studies that we attach to the complaint, but the Erie Medical Society weighed in along with 5 other medical societies and said those facts are junk science, that you cannot easily clean it. Now, that's a fight for...
There's a difference between easily clean and clean.
And they said you cannot clean it. Even...
So if, I don't know where you found the COVID, but
Yeah.
let's say you found it on a table where someone eats.
Yeah.
Are you saying these studies now say you have to somehow properly discard this table because you can never use it again?
No, Your Honor. What they're saying is, and this was a Northwell study, actually, that came out very recently that the Erie Medical Society put forth. They said even if you do very, very deep cleaning,
Yes.
you can't clean it. It has to basically disperse by itself. Now, the problem with that, obviously, is that new COVID is being reintroduced as the restaurant is being opened. So the bottom line is, you really cannot clean it. Now, counsel suggested you can, and he's entitled to those facts, but not on a motion to dismiss. We've alleged facts that make it clear that the surfaces have been physically damaged through the foamite process. He disagrees. We've made it clear in our complaint that you cannot
But even with the science that you allege makes this point for you, you can use the table. There will come a time when you can use that table, and you are using the table.
That is true, Your Honor, but this policy expressly contemplates temporary damage.
So what's the point of the word physical?
Okay, physical, it has to be a physical event like...
And he says there's no such thing as physical event as a phrase recognized in the policy.
Well,
So why should we read in the extra word?
because first you have to look at the word loss, because physical modifies loss.
Yes.
Loss is not defined in the policy. It's construed against the carrier. It's their form. If you go to the dictionary, it says dispossession, okay? So then you have to figure out how does physical modify dispossession? And a reasonable policyholder would assume that if you have a physical dangerous substance that goes onto your property and physically makes the property unsafe, that you are dispossessed.
Yeah, but
you're
you're
lost.
modifying something else with that.
I'm sorry, Your Honor?
You're modifying something else now with this, what you're advocating should be the proper analysis and reading.
I'm not, because physical has to mean something, and what I'm saying physical means something physical happens on your property, and that would
If we
be...
disagree, you lose, correct?
Disagree, we lose
With
on...
that particular view.
With respect to physical loss, yes,
I
but...
know counsel never likes to admit it's a yes or no answer, but it really is.
But, Your Honor, this is what I would really request, is the entire argument was based upon his view of what COVID can and cannot do. This is on a motion to dismiss stage. And so we would ask, we've alleged the things that we need to ask. Now, one other point I wanted to make. Judge Garcia kept on asking, and I believe maybe others did too, is what does physical loss mean that's different than physical damage? And counsel said it means complete dispossession. And the question was, what's the support for that? There is no support. In fact, the policy expressly says the otherwise. If you go to record site 113, expressly states that economic damages due to physical loss or damage can be as partial or in whole. So the policy expressly contemplates that the physical loss can be partial or in whole. There is no support that physical loss means complete dispossession. It doesn't say complete loss, it says physical loss.
Thank you.